So multiple cases seeking to strike down state bans on so-called assault weapons are now seeking Supreme Court review. So let's talk about what is happening. But real quick before we jump into this video, if you agree that rifle bans and magazine bans are clearly unconstitutional, go ahead and hit that like button and subscribe. Also want to thank the sponsor of this video, which is Kershaw Knives. Kershaw makes some of the best knives available on the market if you're looking for a quality EDC knife. I carry a Kershaw Iridium knife every single day for my EDC, and I cannot recommend their knives enough if you want something that just works. And right now, if you order using the code 2024SCHOLAR40, you can get 40% off of your order. So head on over to Kershaw Knives, pick yourself up a quality EDC knife, use that code, and thank you again to Kershaw Knives for supporting and sponsoring this two-way content. As I mentioned in the intro, in this video, I have some important news for you on the current battle to strike down the state of Illinois' ban on so-called assault weapons and also their magazine ban. These current actions are huge, and they have huge implications not just for the state of Illinois, their rifle ban and their magazine ban, but a ton of other states, including California, New York, New Jersey, and every state that has a rifle ban and also a magazine ban. There are now multiple cases which are once again going up to the United States Supreme Court, asking for the court to review and strike down this Illinois rifle and magazine ban. Again, this has huge implications. The cases we're going to be focusing on and breaking down in this video are the NAGR versus Naperville case, and then also the Harrell v. Raoul case, or formerly known as the Barnett v. Raoul case. These cases now seek to get the United States Supreme Court to finally intervene and stop lower court defiance of what the Supreme Court has said in multiple rulings, including Heller and Bruen. Now, you may recall that recently we received news that the United States Supreme Court denied 2 emergency injunction requests, which were asking for the Supreme Court to put a temporary halt on the Illinois statewide rifle ban and then also their magazine ban. Those cases were Colkins v. Pritzker, and then also the same case NAGR versus Naperville. Those cases, of course, involved a challenge to the Protect Illinois Communities Act, or PICA, which places unconstitutional restrictions on rifles and magazines. PICA also requires a registration requirement to grandfather in already possessed rifles. In Colkins, after a state Supreme Court's decision, the plaintiffs in that case filed a writ of cert to the United States Supreme Court. In the Colkins case, the plaintiffs also filed an additional emergency stay request pending Supreme Court review to Justice Barrett, who is responsible for emergency motions that come out of the 7th Circuit. However, the Supreme Court denied both the request for the emergency stay, and then later they also denied taking review of the case after they held conference on January 5th. The second case that was denied an emergency request was the NAGR case, which is now also seeking a Supreme Court writ of cert. In the NAGR case, the plaintiffs also filed for an emergency intervention, but again, the Supreme Court denied the request for an emergency stay. Then also the 7th Circuit en banc panel denied review in the NAGR case, along with multiple other case challenges against PICA. NAGR, however, still had options after those denials. After the Supreme Court denied their emergency stay, after the en banc panel decided to not take the case up for review, the main option they had was to file a new and traditional writ of cert to the United States Supreme Court, which that is what they have now done. Now, there was also another case which was challenging the Illinois rifle and magazine ban, which has now also filed for Supreme Court review. That case was the Barnett v. Raoul case, or the Harrell v. Raoul case, which is supported by Second Amendment Foundation and then also Firearms Policy Coalition. Now, this case is a case we've talked about before on this channel, and it was one of the multiple cases that were recently also denied 7th Circuit en banc review, even after the 7th Circuit applied the incorrect Second Amendment analysis. This case started out in a lower court in front of Judge McGlynn, and Judge McGlynn issued a preliminary injunction which temporarily halted the enforcement of PICA. The state of Illinois, of course, didn't like that, so they appealed the injunction, the preliminary injunction, up to the 7th Circuit, and on review, a 3-judge panel of mostly just super anti-gun judges removed the preliminary injunction and ruled against the pro-2A side. Now, in coming to that decision, that 7th Circuit 3-judge panel used an analysis that did not align with either Heller, either the Heller common use test, or even the most recent Bruen holdings. Instead, that 7th Circuit panel concluded that the arms protected by the Second Amendment do not include weapons that may be reserved for military use. So they used the military use test, which does not align with the Supreme Court's precedent in Heller or Bruen. This is the same test also used by the 4th Circuit in the Bianchi v. Frosch case, which was also seeking Supreme Court review, is currently up for a writ of cert before judgment, And again, Bianchi challenges Maryland's rifle ban and some of the things that they have in place in that state. So not only now do we have multiple cases coming out of Illinois, out of the 7th Circuit, going to the United States Supreme Court, seeking for them to review and strike down rifle and magazine bans, but then you also have that Bianchi case coming out of the 4th Circuit, challenging Maryland's ban as well. Now in the Harrell case, the question presented to the United States Supreme Court is whether the Constitution allows the government to prohibit law-abiding, responsible citizens from protecting themselves, their families, and their homes with semi-automatic firearms that are in common use for lawful purposes. Now, of course, if the Supreme Court grants review in these cases and ultimately rules in these cases in a favorable way, that has huge implications not just for the state of Illinois, but all other states, including my state, the state of California, which has similar rifle bans and magazine bans. So that's why this is so significant. Now, the biggest hurdle with these Illinois cases, I will be honest, is the fact that both of these reviews is a preliminary injunction consideration. That means that these cases are up for Supreme Court review primarily on an interlocutory posture, and there's not been a final merits review in either of these cases. Traditionally, Supreme Court does not like to review cases on an interlocutory basis, so right now there is currently an uphill battle to even get these cases to be granted review. The Supreme Court has denied review in these cases and other cases coming out of Illinois on interlocutory postures, so again, an uphill battle. But FBC and SAF are trying to overcome that hurdle by arguing in their petition that although petitioners are coming to the court on an interlocutory basis, the current state of the courts of appeals on this issue and the patently erroneous nature of the decisions below provide good reasons for this court to take this case now and settle these issues once and for all. Indeed, the 7th Circuit's opinion virtually guarantees that nothing will be gained by waiting for a final judgment. Absent certiorari, petitioners alongside with other plaintiffs in the cases below will try to prove their cases by presenting evidence and expert testimony aimed at satisfying the 7th Circuit's misguided and opaque military weapons standard. But this court has already settled that arms bans are unlawful to the extent that they prohibit arms in common use. Whether the banned arms are useful to the military is an entirely irrelevant consideration, and none of the record that is likely developed in this case will have any impact on the court's analysis. Rather than waiting for the development of a record that will be irrelevant under the Heller standard, the court should grant certiorari now. What this means is the plaintiffs take the position that waiting for the lower court to rule in this case, develop a record, and rule the merits, and ultimately just rule on the defunct military use analysis is essentially pointless. It doesn't even matter. Why wait all that time for the lower court to issue a ruling that is clearly wrong, using the wrong analysis? Instead of waiting all that time, why doesn't the Supreme Court just step in right here and now, say the military use test is not appropriate, it does not apply here, the Supreme Court should faithfully apply their Heller analysis, say that these items are in common use for lawful purposes by law-abiding people, and strike down these rifle and magazine bans. That is what SAF and FBC want. Now, I also want to note that there are still multiple cases, including the Harrell case and some of these other cases, which are being re-reviewed in the lower courts in front of Judge McGlynn. So although some of these cases are also seeking Supreme Court review, they're still moving towards merits reviews in the lower courts. Now, after the 7th Circuit en banc panel denied review in a bunch of these cases, those cases were sent back down to that lower court judge. And recently, that lower court judge, Judge McGlynn, held conferences on all these cases. And some of the attorneys there, even some of the Pro 2A attorneys said, hey, we want to put these considerations on hold. We want you to just grant a temporary stay, kind of put these in abeyance because we're going to seek Supreme Court review. But ultimately what Judge McGlynn said is, no, I'm not going to halt any of these cases. I'm going to allow them to proceed forward. We're going to move these towards a merits review. And ultimately, yes, if you seek Supreme Court cert and Supreme Court grants review in these cases, if they do anything in these cases, well, then maybe I'll hold these cases in abeyance and put them on hold. But until then, and until that time, he is going to proceed forward with these cases on merits reviews, trying to get to a final resolution of these cases. Now, in my opinion, I think the Illinois cases are still a long shot, but I think the Bianchi Maryland rifle ban case, which is up by a writ before judgment, it's up on a writ of cert before judgment, that one has a good shot, especially when you look at the fact that that case was GVR'd before it was granted, vacated, and remanded by the United States Supreme Court after the Bruen decision. I think the Bianchi case has a better shot because it's on a motion for summary judgment. It's a final merits decision, so that one has a better chance of being granted. And of course, if that one's granted, then I think either maybe these Illinois cases are going to be wrapped into that, kind of consolidated with that and argued with that, or they'll just be put on hold and then granted, vacated, and remanded after any positive decision in Bianchi. So generally good news, you have a bunch of rifle ban cases coming out of Illinois, going to the United States Supreme Court, the Maryland case as well. And really now it's just entirely up to the Supreme Court on what they want to do. So that's what's going on. If you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.